Barron v. City of Baltimore, USMD. 1833, 32 U.S. 243, 7 Pet. 243, 8 liters. Ed. 672. The Constitution emanated from the people, and was not the act of sovereign and independent states. McCulloch v. State, U.S.M.D. 1819, 17 U.S. 316, 4 liters. Ed. 579, 4 wheat. 316. The Constitution of the United States was ordained and established not by the states in their sovereign capacities, but emphatically, as the preamble of the Constitution declares, by the people of the United States. There can be no doubt that it was competent to the people to invest the general government with all the powers which they might deem proper and necessary, to extend or restrain these powers according to their own good pleasure, and to give them a paramount and supreme authority. Martin v. Hunters. Meant and the Union which it created, and the states which were incorporated into the Union, would be indestructible and perpetual, as far as human means could accomplish such a work. It intended to make them so. White v. Hart, U.S. Ga. 1871, 80 U.S. 646, 20 liters. Ed. 685, 13 Wall. 646. The Constitution of the United States established a government, and a league, compact, or partnership, and it was constituted by the people. Legal tender cases, U.S. Text. 1870, 79 U.S. 457, 20 liters. Ed. 287, 12 Wall. 457. See, also, U.S. v. Cathcart, C.C. Ohio 1864, 1 Bond 556, 25 Fed. Cass. Number 14756. The Union of the States began among the colonies, and grew out of common origin, mutual sympathies, kindred principles, similar interests, geographical relations, and received definite form, and character, and sanction from the Articles. Through the U.S. Printing Office website www.gpo.gov web link action, and on the website for the Library of Congress, www.loc.gov web link /help/guide/federal/usconst.php/. See Figure 5.2b. The second publication is Constitution of the United States of America as amended, unratified amendments, and Analytical Index. A helpful feature in this publication is the analytical index to the articles and amendments. The publication is found on the website for the Library of Congress. See Figure 5.2c. Because the Constitution is a public document, it is also found on many educational and commercial websites. Each state has a constitution. Like the U.S. Constitution, state constitutions are published either separately or with the state codes. They are also found on the Internet, generally through the state's official homepage. A website providing a link to all state constitutions is www.stateconstitutions.hum.edu weblink. A point to remember. State constitutions should always be reviewed when researching a constitutional question. Remember that when you research an issue controlled by the Bill of Rights, your state constitution may give an individual more rights than he or she has under the U.S. Constitution. If this is the case, your research must focus on your state constitution and on cases that interpret your state constitution, as well as on the U.S. Constitution. 5.3 Federal Statutory Law Enactment of Statutory Law. In the U.S. system of government, legislative bodies have the power to make laws. These are statutory laws. Unlike case law, statutory law is not enacted to receive a specific factual dispute. Instead, legislative bodies make rules or laws that aid to society in general. Statutory law governs many aspects of our lives. Bearing arms. Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In general. In spite of extensive recent discussion and much legislative action with respect to regulation of the purchase, possession, and transportation of firearms, as well as proposals to substantially curtail ownership of firearms, there is no definitive resolution by the courts of just what right the Second Amendment protects. The opposing theories, perhaps oversimplified, are an individual rights thesis whereby individuals are protected in ownership, possession, and transportation, and a states' rights thesis whereby it is said the purpose of the clause is to protect the states in their authority to maintain formal, organized militia units. Whatever the amendment may mean, it is a bar only to federal action, not extending to state 2 or private 3 restraints. The Supreme Court has given effect to the dependent clause of the amendment in the only case in which it has tested a congressional enactment against the constitutional prohibition, seeming to affirm individual protection. 1. A sampling of the diverse literature in which the same historical, linguistic, and case law background is the basis for strikingly different conclusions is, Staff of Subcom. On the Constitution, Senate Committee on the Judiciary, 97th Congress, 2d Sess, The Right to Keep and Bear Arms, Com. Print 1982, Don B. Cates, Handgun Prohibition and the Original Meaning of the Second Amendment, 1984, Gun Control in the Constitution Sources and Explorations on the Second Amendment, Robert Jack Cottrell ed., 1993, Stephen P. Halbrook, That Every Man Be Armed, The Evolution of a Constitutional Right, 1984, Symposium, Gun Control, 49 Law and Contempt. Probs. 1, 1986, Sanford Levinson, The Embarrassing Second Amendment, 99 Yale LJ 637, 1989, Joyce Lee Malcolm, To Keep and Bear Arms, The Origins of an Anglo-American Right, 1994, Glenn Harlan Reynolds, A Critical Guide to the Second Amendment, 62 Tennessee. L. Rev. 461, 1995, William Van Alstyne, The Second Amendment and the Personal Right to Bear Arms, 43 Duke LJ 1236, 1994,